Demystifying Mediation with Dr. Rob Kiter, CERC Program Coordinator. November 20th, 2024. CERC's Wisdom Wednesday webinar series.
Welcome to the November 20th, 2024 Wisdom Wednesday webinar presented by the Special Education Resolution Center. My name is Rob Kiter. I am the CERC Program Coordinator, and I'll be hosting today's webinar along with presenting on the topic of demystifying mediation. After my presentation, our Assistant Director, Dr. Allison Conch, will be introducing our panelists who will be addressing questions related to today's presentation. Couple of logistics I want to mention to you. I believe that I put in the chat a mediation at a glance flyer that we've just developed. If I haven't, Allison, if you could get that in there, I believe I did, but I can't see it right now. But we wanted to provide that to you as a handout to go along with this. Also, you won't be using your audio or video, but if you have questions for the panelists, there's a Q&A section where you can type in those questions. And if you put them in the chat, we'll also see them. After this presentation's over, we're going to be addressing any live questions as well as some other questions that we've thought about in advance. You can use emojis such as chat, with the chat, such as thumbs up or down or raising your hand. If you have, again, I already mentioned, if you have any questions regarding this, go ahead and type those in the Q&A or chat. We are also providing real-time closed captioning during this webinar, and you can click on the CC Live Transcript button at the bottom of your Zoom screen to either turn on or off captioning, as well as to adjust the size and other settings. We are recording this webinar and we'll be making the recording available on our website. It'll probably be there in a couple weeks. We may also be using this on our mediation page, the mediation page of our website. When we make this available on our website, the materials that go along with this will also be on the Wisdom Wednesday webinar page. There's a survey we're going to ask you to complete at the end of today's webinar that Allison will be mentioning to you again. And that's just some basic things we wanted to share with you before we actually get into this material. And so again, the topic of today's webinar is demystifying mediation. And this isn't going to be all things mediation, but we wanted to give you a good overview or introduction into what is mediation. So basically the who, what, when, where, and how to help you better understand one of our really important dispute resolution services that we provide, mediation. I'm going to start going through this now. Let me just make sure. Okay, so first of all, let's see if I can make that a little smaller. Okay, just a few things in terms of our background so that you understand more about us. We are a third-party neutral organization, that is CERC, the special, and I'm going to call it CERC from now on instead of Special Education Resolution Center. We're a third-party neutral organization, and our mission is to help families and schools resolve disputes at the earliest stage possible. Special Education Resolution Center, CERC, serves in partnership with the Oklahoma State Department of Education and the Oklahoma State University Department of Wellness, and sponsor programs is the lead agency. CERC is not an advocate for families or schools, but we work with both in supporting the IEP team process and in providing dispute resolution services and other things that we'll talk about in a minute. And all of our services and trainings are provided at no cost to families or schools. And we have to mention this a lot of times because it's really easy to misunderstand this, but sometimes families and maybe schools look at us and feel like maybe we're an advocate for them. And we just have to keep saying this. We're not an advocate for one or the other. The way I like to share it is if I'm providing any kind of a service, such as mediation, I would say I'm not an advocate for the family or for the school. I'm an advocate for the process of helping you work together to resolve conflict, or if it's IEP meetings, helping you work together to collaborate. So it's important to realize that. The purpose of CERC, really, we kind of have a twofold purpose, two sides of the coin. We provide stakeholder training and we provide dispute resolution services. And I know I've got trainings on the left, but I'm going to start with services. On the services side, we do a lot of consultations, individual debriefs. We encourage parents, we encourage schools to call our office so that we can talk with you. You may have questions about what's going on, or about the IDEA, or about maybe conflict situations and wondering, where to go from here. So we would love to talk with you. We won't advise you or tell you this is what you should do, but we love being able to talk with individuals, maybe as part of helping you decide what would be most appropriate for you. And then beyond those consultations and the intake on the phone and email, we provide IEP facilitation. And that was our topic in last month's Wisdom Wednesday webinar. And that's where we're sending one of our mediators who also serve as a facilitator to help the IEP team, maybe if its meetings are becoming conflicted, or there's some really sensitive discussions coming up, or you just feel like the team is having a difficult time being able to share with each other, listen to each other, collaborate together. We'll send a facilitator to help and assist that team, and hopefully having a really good conversation. We also provide mediation, and that's what today's presentation is going to be on. And then if due process has been filed, within the first 15 days of filing, there'll be a resolution session, unless waived by the school and the parents. But that's an opportunity for the school and family to get together prior to a hearing starting to see if they could possibly resolve this dispute. When that happens, we make available to the school and the families a facilitator. And that would, again, be one of our mediators. It's called facilitation simply because it's a resolution session, but it's very similar to mediation with a few differences. So those are our services. And then on the other side of our purpose, we provide stakeholder training to build capacity at the local level. We do a one-day facilitation training. That training is for anyone that has the responsibility of facilitating meetings. It might be an IEP team meeting, but it could be any type of meeting, and especially difficult meetings. And this one-day training will help you learn new skills or sharpen your existing skills, as well as learning techniques and strategies for engaging conflict within meetings. The facilitation training is offered regionally in Tulsa, the Tulsa area, and the Oklahoma City area, and rotates every month. Then we offer a two-day training called Crucial Conversations for Mastering Dialogue. That's a registered, trademarked international training that we're licensed to provide in the education context. And that two-day training is really designed to help you learn how to communicate in a way where you can get the results that you want and need through your interactions. That's a two-day training. It's also offered regionally in Oklahoma City one month, Tulsa area the next month. And both of those trainings, really along with all of the trainings we provide, are offered at no cost. And that's through our partnership with the Oklahoma State, through our contract with the Oklahoma State Department of Education. Our webinars that you're attending today and that we have throughout the year are also at no cost to you. And then we'll do custom trainings as requested to different districts and groups. Once again, we don't serve as advocates for families or schools individually, but we work with both in supporting the IEP team process. All of our services are free. So let's get right into mediation today. Again, this is an overview, and then we're going to have some practical questions afterwards. First of all, just want you to understand mediation can help parents and school district resolve disagreements about the education of a student with disabilities. And as an alternative dispute resolution process, what we mean by that, it's an alternative to litigation, an alternative to a lawsuit or a due process hearing. And so as an alternative dispute resolution process, mediation encourages open communication, problem solving, and positive relationships between parents and schools. Some of the specifics to understand mediation can happen at any time for any issue under the Individual with Disabilities Education Act. The focus of mediation is always on the student's needs and on their education, not on disagreements between the parents and the school district. And mediation under IDEA requires a neutral third party to be present and conduct the session. I want to talk a little bit about some expectations so that everybody can be on the same page regarding what's happening in mediation. So first of all, both parties, the parents and the school district, should approach mediation with the intention of reaching an agreement. In the agreement to mediate that the parents and the school district will be signing, it talks about the parties coming to mediation in good faith. And that's what this means. You can't promise it, but you're coming to mediation with the intention of reaching agreements that resolve the dispute. Secondly, the mediator is not an advocate for the parent or district. The mediator is a neutral third party. We're impartial. We work evenly with the parties. Also, the mediator is not an arbitrator and does not make any decisions for the parties regarding the issues that are in dispute. The terms of the agreement, if there is an agreement, if there are agreements that are written up, they are developed by the parties with the assistance of the mediator who will draft the agreements. This is a really important expectation because some of the times the parties, and it might be the school, it might be the family, some of the time they think maybe that the mediator makes decisions for them. That's what happens in arbitration, but that's not what mediation is about, because in mediation, everything is up to the parties and they make all of the decisions. Also, discussions in mediation are confidential by law and cannot be used in any future civil proceedings related to the topics of mediation. So if anything was to go on to due process or any other type of litigation, the conversations that take place in mediation are off the record. They can't move forward. And we spent a good bit of time at the beginning of mediation helping the parties understand this. But in light of this, the mediator does not record mediation and asks the parties not to record. We also, as mediators, will destroy our notes that we take during mediation. We take notes so that we can stay on the same page with the parties, maybe regarding proposals and counter proposals, so we can keep up with the discussions. But at the end of mediation, those notes are shredded, and the only thing that remains would be the written mediation agreement, which we call Memorandum of Understanding, and that will be signed and go with the parties. Everything is confidential, and that's a wonderful benefit in mediation. It means that the parties are free to share what they're thinking, what they're feeling, and not have to worry about that being part of the court record. A few more expectations. Mediation is not a substitute for independent legal advice. The mediator will not provide legal advice because of that. Now, the parties are encouraged to secure independent legal advice as needed throughout the mediation process. But this is an important one because, once again, sometimes the parties, not only may they think that the mediator is going to make decisions on these issues, but sometimes they also think that the mediator will say this is what the law says, or that the mediator is going to be an arbiter of who's right and who's wrong, or whether FAPE is being provided or isn't being provided, and that's not the role of the mediator. Also, mediation is at no cost to the parties. Parents and school districts do not have to pay for mediation services provided by CERC. Another thing that I think is real important regarding the expectation is just the time frame. We say that mediation sessions could take up to a full day. Generally, that's not the case. Generally, sessions can be completed in 3 to 4 hours, depending on the complexity of the issue or issues. Also, depending on the willingness of the parties to negotiate in good faith, their willingness to make concessions and work together to try to reach agreements. But just understand that usually mediation does not take the whole day, but we recommend that participants plan to set aside a full day, even though the session's likely to conclude in a shorter period of time. You wouldn't want to just be planning on an hour and a half or 2 hours for mediation. You're getting into good discussions and negotiations, and all of a sudden you have to leave. That would really be a problem. Allison, I see you looking on. Would you like to share anything about that?
Well, yeah, I think you're right. It does vary greatly. I mean, I've been with Circ only for a year now, but I don't know that we've had any mediation that's lasted less than 2 hours. And you have more experience in obviously mediating those sessions, but we've had more than one in the last year that have lasted 5, 6 hours. So yeah, I think it just depends on the complexity, like you were saying, the complexity of the issues, how many issues there are, and what those negotiations, how creative people are willing to be, right, in their negotiations. So it varies widely, but people coming in thinking you're going to get knocked out in an hour is not feasible.
Right. Yeah, thank you. That's the main thing there, just to plan to set a good period of time aside, like we're saying, just the day or the evening if it's a mediation in the late afternoon. Some requirements: who has to attend? From the school district, there has to be a school district representative with legal binding authority for the district. So that's usually going to be the special ed director, maybe a principal, possibly a superintendent, but somebody from the district that has legal authority. And then any other school district employees that have important expertise on the student related to the specific issues that are going to be on the table in mediation. That's who needs to be there from the school. Now, from the parent or the adult student, obviously the parent or adult student has legal authority, representing themselves, so they have to be there. And then from CERC, we are going to provide a neutral mediator that's been trained in IDEA basics and in communication, mediation, negotiation techniques that can help the parties discuss the issues and negotiate together and guide that process. Those are the required parties. There may also be, we're saying, optional participation in mediation from the school district. The school district might have an attorney present in mediation. This would be at their discretion and at their expense. For the parent or adult student, they might have additional parents or a student, if not an adult, or other non-school service providers who have knowledge of the student related to those issues in the mediation. They might be there with the parent. Also, the parent is free to have an attorney with them if they wanted to do that. That's at their discretion and expense. The parent might have an advocate with them. That can be a really beneficial a person in mediation, or even a friend or other person that they would like. It's up to the parent who they would choose. But you've got your required parties in mediation, and then these are some optional parties. The service purpose: mediation might be appropriate anytime there are clear disputes between parents and educators about special education or related services. So I mentioned it earlier, when folks are calling us, and we're not saying this is what you have to do, but we try to explain the differences. when there's just maybe difficult IEP meetings that are becoming conflicted and hard for the parties to listen to each other, to work together and collaborate, well, maybe sending a facilitator to help them would be appropriate. But when there are really clear disputes related to IDEA, that's where mediation might be even more appropriate. We're leaving it up to you, but it might be more appropriate because those issues can once again be discussed, negotiated in a confidential setting, and what you can end up with is a written agreement that's enforceable in any court of competent jurisdiction, in any state court, district court. So that can be really helpful. That's where mediation might really be appropriate. Now, we went ahead and gave you the statute reference under IDEA. This is 34 CFR 300.506 of the Individuals with Disabilities Education Act. It says that mediation is available to parents, adult students, and school districts. It is a voluntary process. And that voluntary process, you're going to see how each of these little sections of this statement here will come out. Both parties have to agree. That's the first agreement that they reach, is whether to use mediation, to have mediation. But it's a voluntary process in which all parties work to reach agreement through a confidential process that is more structured than a parent-teacher conference, but less formal than a due process hearing. Mediation is informal. All parties are encouraged to be respectful and working towards an agreement. So we're going to say a lot more about it, but I wanted you to see that reference from the statute.
Hey, Rob.
Yeah.
I want to go back to the point about the like the service purpose and the clear disputes, just to clarify some things, because this happens a lot when we get calls from parents, and you touched on it a little bit, but there does have to be clear issues. It doesn't mean they have to be a certain level of issue. But if there are not clear issues of disagreement, if it's just like you said, well, I'm just really mad about how these meetings have been going. I mean, you could certainly try to turn in a request to mediate, but we're not going to be able to mediate if you don't list issues. That's a required piece that we have to be aware of, because a mediator can't come in to say, how do we resolve a non-issue? So if there's not clear issues, that's when we might say things like, well, mediation might not be appropriate for you because we've got to have an issue. It doesn't have to be a certain level or a certain heightened conflict, but there does have to be some sort of an issue or dispute. Whereas when we get calls, like you said, Rob, of, well, these meetings were just kind of spinning, going in circles, getting nowhere, they're highly combative or lots of conflict, then again, depending upon if it's related to issues or just in general, it could go either way. But I think that that's kind of a misperception, that sometimes parents will think, oh, well, it's really combative, so I need to do mediation. It's like, well, not if there's not issues. Or, oh, I can't do mediation because my issues aren't that big of a deal. No, if there's specific issues, you can do that. But that we do take care of that information, like Rob said, during the intake calls, but just the more we can put out there about what that could look like, hopefully the better informed parties are.
Yeah, thank you for sharing that. Also, and I think this will come up in a later slide, but it's not just clear specific issues, but clear specific issues directly related to the student's education, related to the IEP or to FAPE, to IDEA, not issues, personality conflicts and such between, so it's clear specific issues directly related to IDEA. So thank you for bringing that up. Okay, how to request mediation. Remember, it's a voluntary process. Either party, and this is similar to IEP facilitation, either the school or the parent may request mediation, but both parties have to agree to mediate. That's the agreement, and they'll sign that. So the process is contact CERC for an intake call. If a service is needed, you'll complete agreement forms. And both the school and parent will do that. And the parent, excuse me, also completes a consent to release information form, confidential information form, and you'll send those back to our office. And those forms are available on our website. or also by contacting our office by phone or by email. So that's the first step, how to request. Now, the procedural steps after you've made that request. Once an agreement from the parties is received, we'll work with the school parent and assigned mediator for a mutually agreeable location and time. And I think we say this in another slide, but if we receive a request for mediation, let's say from a parent, then we're going to reach out to the school to see if they're agreeable to this and get their form as well. And then once we get both of them, we're working to see if we can schedule a time, location, and we will also be scheduling a mediator. This may be scheduled within a few days or weeks of the initial request. Just a little bit about our mediators. We have a wonderful panel of mediators. We have 9 mediators at present, including myself. And our mediators, who I should say they also serve as facilitators if we're offering IEP facilitation. But our mediators are assigned to cases on a random rotational basis. Now, it might be if there was a need for a continued session, let's say in mediation, and there was one mediator that was working with the parties, it's very possible in that situation that that mediator would be brought back for the continuation. But just understand that we use this random rotational basis for assigning mediators. And as I said, we have 9 mediators right now. What's the mediator's role in the session? So the mediator leads the mediation session with the goal of helping the parties resolve specific matters in the dispute by reaching agreement on those issues. That's the goal, reaching an agreement that resolves the dispute. The mediator does a number of things as in managing the process and leading the meeting. They help the parties discuss the issues. They help them negotiate with each other, help them explore options that might lead to solutions that are mutually acceptable and will resolve the dispute. Important to know that during mediation, the mediator may meet with the parties together. Typically, that's the way we would start mediation. Sometimes we'll stay meeting with the parties together throughout the length of mediation. But we also can meet separately with the parties, and we call that caucusing. So I don't have any more about it in the slide, but just briefly so that you could understand this. As I said, a lot of times we're starting off together. I would typically always try to start together so I could set the tone and make sure our expectations were all on the same page about what we're doing. But just understand that after meeting together, I let the parties know that because mediation is informal, if at any time the school or the parents wanted to meet separately with me, they could just simply say, Rob, can we meet separately with you? Now, the reason that that might happen, just as an example, let's say that one of the parties is considering making a proposal to the other, or maybe a proposal's been made to them and they'd like to reality test that a little bit and think about that out loud. Or maybe they just want to talk about how they feel like things are going right now in mediation. There could be a number of reasons that they could simply say, can we meet separately? If I meet separately with one party, I'll say, sure. And let's say I'm going to meet with the parent. Typically, I'm going to go and meet with the school after that. And I'm always going to let them know how long we're going to, they can expect me to be in those sessions so that they're not out there just wondering what's going on. And then as a mediator, I'd really have the decision to make, do we bring everybody back together and continue on together? Or should we stay meeting separately a little bit back and forth? I also let the parties know that not only is that something they can request because of the informality, but if as a mediator, if I feel like the parties are stuck, they're really at impasse, and I'm feeling like it might help them move forward by meeting separately with them, asking some different questions, working with them individually a little bit, then I might suggest that we meet separately. But just understand that possibility exists, meeting together in what we call joint session or meeting separately in caucus session. Agreements reached in mediation After they become specific, they're going to be drafted by the mediator in what we call memorandum of understanding. The parties are going to get a chance to review that. And then I say here, signed when satisfied. And what I mean by that is this is all going to typically happen at the end of the meeting. And that's why we want to allow time for this and not be in a rush. But when I come back as a mediator and here we all have the draft of the agreements that hopefully will look and sound very much like the parties were saying, it's also very possible that the school or the parents or both may say, hey, that's close to it, but can we adjust this? It's not, it's satisfying us to the extent it needs to in a particular point, a particular agreement. So that can be tweaked and then, looked at again by the parties. And once they say, yes, these are the expectations we have of ourselves and of each other with these agreements, we're good with them, then the parties are going to sign that agreement. It'll be copied and they'll leave mediation with that. And as I said, mediation agreements that are signed by the parties are enforceable in court. Another thing, just to let you know, I have this picture on here you're looking at of the bus, and we had this same picture in the Demystifying IEP facilitation. So I wanted to include it here because it's a good metaphor to think about the role of the mediator. In IEP facilitation, I told them the role of the mediator isn't to drive the bus, but to sit on the front row behind the bus driver and assist the team, the people on the bus, assist them in having the best conversation possible as they're working with the goal of collaborating to make decisions in an IEP. Well, in mediation, it's different because the mediator really drives the bus. The mediator is in charge, in control of the process, managing the process and the parties if needed. So it's really different. And when I go into facilitate an IEP meeting, I set the tone, I set things up for hopefully success collaborative wise, and then I turn things over to the school and assist as needed. In mediation, I start mediation and I lead throughout whatever it is that we're doing in mediation. So just understand the difference there. How to prepare for mediation, just some practical things. So first of all, for families, make no other plans for the day or evening of the mediation. Just like we said, allow plenty of time. I think it's helpful to prepare a written list of issues that you want to discuss during mediation. Now, hopefully the mediator will already have a basic idea of what those issues are prior to mediation, but we always want to allow the parents, family, and the school to bring us up to speed with where things stand on the issues to be resolved when we actually get into mediation. So have that clear written list. This is what we want to discuss. This, and I think it's also good just to think about, here's what we'd like to accomplish today. And then you're going to be sharing. So prepare to respectfully share your concerns and point of view. I don't have the IEP communication guidelines here, but I'm thinking about them because it's a similar thing here. I'm always saying when you're thinking about how to share whatever you need to say in any context, including mediation, always think about how can I say this in a way that's going to make it easier for the others, the other parties, to hear, to understand what I'm saying and be able to respond to. So I want to be honest, but I also want to be respectful. So we're trying to avoid blaming and accusations and other kinds of comments that really put the other parties on the defensive. I think that'll help you as you're preparing. And you'll notice it's in this sense, it's not just about what you say. It's really about how you say it. Also, your voice is important. So I'm thinking now for families, for parents or adult students. So be careful in allowing someone else to speak for you. Now, a lot of times we have parents will have advocates that'll be with them, and we really appreciate the role that advocates can and so often do play. And some advocates may do a little bit more talking depending on how they have things worked out with the parents. But even if the advocates are sharing, you want to realize as parents that your voice is important. So you don't want to turn your voice totally over to anyone else. Also, be prepared to participate fully in the session for a deep discussion of the issues, because that's what we're going to do. Whether that discussion is with all of us together or whether some of that discussion may need to take place separately. A few more things in preparing. Families, be willing to listen and carefully consider others' ideas and possible solutions. And that just I think is important, maybe just to underscore. Uh, it might be easy to come in and say, well, I've already heard all I need to hear. That's why we're here in mediation. But the truth is, I would encourage you to come into mediation with an openness to listen, like it's the first time even, to listen for understanding. Because, and that when I talk with folks about listening during mediation or even other meetings, I use the phrase, try to listen as an ally instead of an adversary. Because if you see the people here, even though you're in dispute, that you still are allies for the student's education. And if you listen with an openness to hear something that might work as a solution, or that might, with a little bit of adjustment, lend itself toward what might truly be a solution to resolve dispute. Just be open to listen in that way to the other's ideas and possible solutions, and they'll do the same with you. This says this about, it should say think about, I apologize for that. Think about what questions you want to ask the other party and what proposals you want to make. This is really important. What questions would you want, if it's the family, what questions would you want to help the school, that hearing from them would help you a lot in these discussions? And what proposals do you want to make that would move toward resolving the issues that are in dispute? Think about those proposals. Also, think about what concessions you might be willing to make to resolve the dispute, and that would be get it resolved and be able to put it behind you so that you could move forward. What concessions would you be willing to make? And then finally, just arrive a little before the meeting so that you have plenty of time to get ready to participate. Now, I've got the same thing for schools, and they're similar. They're not totally the same, so don't make any plans for the day or evening. Prepare a written list of issues, same thing there. Have only required parties at the meeting, along with those whose expertise and feedback is essential. The IEP team, the school team might have 8, 10, 12. I've been in meetings that even have more than that, people in the IEP team meeting. But do you really need all of those folks in mediation? And that's, I think, really important to think about, because communication is difficult enough already. You want those that are required, that is the person with authority to bind the district, and then those that really have information that needs to be shared and be part of the discussion. That'll help you. Carefully consider whether an attorney is necessary at a meeting, because we said that's up to the discretion and at the expense of the district. But I think it's just something to think about. Do you really need an attorney present? The attorney might cause the parents might, cause them to question trust, or cause them to have distrust and possibly prevent a resolution. It's always up to the school, just like it's up to the parent, but be thinking about whether that would be the best thing. I've been in a lot of mediations where attorneys are present for the school district, especially, and most of the time they've been very, very helpful. I've also done a lot of mediations where the attorney wasn't present, but they were available. If we took a break, or the team had been, consulting with the attorney, might need to consult with the attorney if something comes up as a proposal that might resolve the dispute that they hadn't considered before. But just think about this for schools. Definitely, regardless of whether or not attorneys are involved, caution school personnel to speak, just like we talked about with families, to speak in a way that makes it easier for the parents and the family to be able to hear, understand, and respond. I think for the school, it's great to be thinking about questions that you can ask that could help you better understand the parents' main interests and concerns. And then a few other things that are similar to what we mentioned for families: be willing to listen and carefully consider the parents' families' ideas and possible solutions. Think about the proposals ahead of time that you would like to make. Think about what concessions you might be willing to make to resolve this dispute, or what options might be there. Same thing, arrive a little before the meeting so that you have time to get ready to participate. You're kind of centered and ready to really engage. And then if the mediation agreement would change the IEP, you may want to think about having the necessary team members ready to hold a separate IEP team meeting that would reflect those changes in the IEP. Things to think about for mediation in terms of preparing from the school side. The measure of success and more. Well, at the conclusion of the mediation session, the intended outcome is a written, legally enforceable agreement between the two parties. And the impact on relationships, we're always thinking about. Mediation can improve creative problem solving in future IEP meetings. It also might result in better communication and improved relationships as a result of the parties working together to find common ground and reach agreements. Some additional considerations I want to mention to you. This flexible process is dependent upon the parties in the meeting and their willingness to collaborate, compromise, and reach agreement. So it's kind of what Allison was mentioning earlier, and we both spoke about it. Somebody says, what's mediation look like, Rob? Well, I have to say, it depends. No one mediation is the same, because the issues are always a little bit different and nuanced. The parties are different. The dynamics between them are different. Their negotiating abilities and willingness to negotiate and problem solve and be creative, all of those things cause each mediation to be unique. So that it really is a very flexible process. Complex situations may require multiple mediation sessions. That's possible. And then something else important to know, I think we mentioned it last week, but mediation is often a suitable solution for resolving matters in a state complaint or due process request. And so, and a lot of times, that's asked of the parties when the parent files a state complaint. Are you open to mediation? Because we see it, and the State Department of Ed sees it as a great way to try to resolve some of these issues. And I could just say to you that if all of the issues are resolved, that were the issues in a state complaint, then we always mention to the parent and the family has the option to dismiss that state complaint. We don't advise them and say, this is what you should do, but we always want them to know that is a possibility. And I would just say, on a practical level, as a mediator that has mediated a lot of, quite a few mediations that involved a state complaint, that what I'll say sometimes and this is only really when all of the issues that were in that state complaint and part of mediation have been resolved, and they've reached agreement on all of those issues. Something that I'll mention is that for the parent family to consider is that if all of these issues have been resolved, one of the benefits of potentially dismissing the state complaint is that in some way it can allow the parents and the school, the parties, to kind of have a clean slate and have a fresh start in terms of building trust in their relationships moving forward. So that's something to consider. But at the same time, it's totally up to the parent. And sometimes the parents and family will say, no, we don't want to dismiss the state complaint. Just be aware that that's a possibility. And we actually have a place on the memorandum of understanding, the mediation agreement template, where that would be noted if the parent chooses to do that. Some service similarities here as we're kind of wrapping things up a little bit. I want you to again see between IEP facilitation and mediation. As far as the request, very similar. You call CERC for an intake call, complete request forms for either process. CERC's going to follow up with the other party to see whether they would like to either use an IEP facilitator or use mediation. We're reminding you again that in either of these processes, it probably is more true with the IEP facilitation, but we are not embedded in the process to just regularly, come and provide a service. But we're here to help when there is disagreement or potential high conflict situations where there's a need for alternative dispute resolution, whether it's an IEP facilitator or a mediator. Preparation, some of the things that are similar, again, think of the main concerns or issues you want to discuss. Consider the child's needs and opinion, the student's needs and opinion related to their own education. And for whatever the service is, be willing to listen to the other's ideas and think creatively. Impact on relationships, similar as well, can build or strengthen relationships, and either service can improve creative thinking and problem solving in team dynamics. Now here you can see the difference that we mentioned before, the facilitator's role. They attend the session, but they don't lead. They step in as needed for communication, help communication, clarification if needed, bridging the gap, helping the team, orient things toward the future. What would we like things to look like moving forward instead of just being stuck in the past? But in mediation, the mediator role, they are managing the process. They're leading the session by helping the parties discuss the issues, negotiate, explore options, and then actually develop solutions, reach agreements that will resolve the disputes, and writing up those agreements to be a memorandum of understanding. The service purpose for IEP facilitation, understand that this occurs in the context of a regular IEP meeting. We just bring in a facilitator. But the service purpose for mediation occurs outside of the IEP team process, and it is a separate meeting or session that is scheduled. The measure of success for IEP facilitation, hopefully arriving at an IEP in which there's consensus or collaboration working toward that, calculated to meet the student's unique needs. The measure of success in mediation is a written, legally binding agreement between the school and the parent that outlines the specific agreements that have been reached to resolve the dispute. And I didn't mention this before. It might come up on one of these last few slides, but I'm going to mention it just in case. When you think about a mediation agreement, sometimes the parties reach agreements on all the issues that were on the table in mediation. And those would be written in the memorandum of understanding. Sometimes the parties don't reach agreement on all of the issues, but on some of the issues. And in the same way, those issues where agreement was reached, they would be included in the memorandum of understanding. And then sometimes, not as often, there's no agreement that's reached. And if that's the case, then there's no written mediation agreement. But just understand, there's still really, as a mediator, I'm sure I'm speaking for all the mediators here, we're always wanting to help the parties reach agreement, and we'd like to see there be full agreements regarding all the issues. And if that's possible, we're going to work our hardest with that as the goal. But we also realize it can be success when some of the issues are resolved. Because what that means is the parties leave mediation with a clear, enforceable written agreement showing their expectations about the issues that were resolved. And now maybe there's one or several issues that they still can come back and look at. And they can decide, do we want to maybe reconvene the IEP team to talk more about that? Do we want to reschedule mediation at a later date? Give it some more time to think about that, look at our options, come back to mediation. And then, as we say to the parties, the procedural safeguards are always in place, and the parent could file a state complaint if they haven't already, or they could always file due process. But the point is, there are less issues now in dispute. So maybe it's all of them, maybe it's some of them. Mediation session recap: a neutral third party leads the school and the parent through a discussion of the specific issues of the disagreement, with the goal of coming to consensus on one, more, or all of the issues submitted by either or both parties for mediation. So there's the slide I was thinking of. The intended outcome is a written, legally binding agreement between the school and the parent, and improved team problem solving. Other dispute resolution options, as I mentioned, the state complaint. State complaint can be filed by the family, the parent, to the Oklahoma State Department of Education. Now, it needs to be filed on alleged violations of the IDEA, the Individual with Disabilities Education Act. The complaint form has to include statements as to the school's violation. How was IDEA violated? And what are the facts that support the statements of the alleged violations? And they have to have been within the previous 12 months. The Oklahoma State Department of Education is going to review the complaint. They're going to determine if it is sufficient to open up an investigation, and then they will issue a decision, if that's the case, within 60 calendar days. So similar to what Allison and I were mentioning earlier, this is true for state complaints. This next statement: IDEA violations do not include matters such as general anger with the school or the parents, experiences of disrespect from school personnel, general education issues. They have to be related to the IEP, to FAPE, to the IDEA. So mediation, finally, is an option, as I mentioned before, for resolution of IDEA issues in a state complaint, and the parent may choose to dismiss the complaint. So that's one dispute resolution option. And then the other to mention to you is due process. A parent or school may file a due process complaint regarding, again, issues related to the identification, evaluation, or educational placement of a child with a disability, or the provision of FAPE, of a free and appropriate public education. The due process filing has to allege IDEA violations that have occurred within 2 years of filing. And here's the important thing to realize: due process initiates a legal court-like proceeding. It is a legal process that includes legal requirements for both parties, timelines that have to be adhered to, assignment of a hearing officer to the case. It's not a small matter. So, and let me just mention before looking at these last 2 points, this is something, I'm just mentioning it here as a dispute resolution option, but on our website, okcirc.org, we actually devoted 3 webinars to due process: Understanding Due Process, part 1, 2, and 3. And if you're considering filing due process, I'd really recommend you take a look at those, the video and the handouts that go along with this, because I think sometimes parents may not be aware that when they pull the trigger on this, it really is a legal process. Couple of things I just mentioned: due to the legal nature of this dispute resolution process, many school districts will choose to be represented by an attorney once a request is filed. That's at their discretion and their expense. Parents may also choose to have legal representation, which would be at their discretion and expense. I don't know, Allison, if you want to mention anything else about this. My focus isn't on due process, but I needed to mention this.
Yeah, I'm going to co-sign what you said about having going to our website. We have a whole page devoted to due process, and the resources are even like, hey, look at these before you file, look at these once you filed. Because like you said, pulling the trigger, so to speak, feels easy. It's like a 4-page document. And so a lot of times if parents haven't really deeply looked into this, the things that come afterwards come as a shock and surprise as to the intensity and legal nature of it. So yes, I would just heavily co-sign what you stated about looking at the resources before, so you just know what you're walking into.
Yeah, thank you. And one other thing that's not on the slide, but I really want to mention, I recognize as a mediator that there are times when due process is really appropriate for parents and for schools. But I'm always, as a mediator, like even in mediation, if I'm meeting separately with the parties and maybe there's the consideration of due process on the parent or by the family. I'm not going to tell them what to do because once again, that's not my role and that's not CERC's role, but I will let them know one of the real benefits of reaching agreements here in mediation that resolve your dispute is that here you as the parent, along with the school, have the power to craft your own decision. You're in control of the outcome. When you pull this trigger for due process and it goes on to a hearing, unless it's resolved in a facilitated resolution session prior to hearing taking place, you now are turning this over to a hearing officer who will be acting like a judge or an administrative officer of the court or an arbitrator. They will be making decisions. And you will have to run the risk of how they will decide. And so in mediation, you still have the power, you still have the control. So I always want folks to understand that, but I also understand at the end of the day, it's always up to parents and schools what they feel like is most appropriate for the student. Okay. Just in ending, some resources I want to share with you. Obviously, who we are, I've already mentioned. Please reach out to us and let us help you. Cadre is the Center for Appropriate Dispute in dispute in the resolution of special education or special education disputes, I think is what it stands for. But bottom line is they are the OSEP funded nationwide technical assistance resource, and they have tremendous resources that are all related to the context of IDEA and dispute resolution. And we emulate Cadre and we work with them. We partner with them. The Oklahoma State Department of Education, as I mentioned, they will help provide guidance to families, advocates, districts, and aid in continued conversations to meet the needs of students with disabilities. And their service and support allows us to actually provide trainings such as these and the dispute resolution services we provide. The Oklahoma Parent Center is Oklahoma's federally funded parent training and information center they can help to educate parents on their rights, to debrief on meetings, and to support them in their advocacy for their child, including in mediation. And that really is it for my presentation. We want to kind of shift the gears now to be able to have a good discussion with representatives from school, parents, and a mediator today. So I'm going to turn things over to Allison.
Thank you. So first, I want to introduce our panel members for today, and we are so grateful that they are here representing kind of the parent perspective. We've got Sharon Long, who is the Executive Director of the Oklahoma Parent Center, and Ellen Kimbrell, who is the Associate Director of Oklahoma Parent Center. So thank both of you guys for joining us today. Appreciate your presence. And then we've got Jackie Johns, who is the Director of Special Services at Collinsville Public Schools, heading up our school perspective today for mediation. Thank you, Jackie. And then Russ Cochran, who is one of the mediators and facilitators for Special Education Resolution Center. So thank you, Russ, for joining us as well. Okay, so I'm gonna throw questions at you guys. I'll probably direct some directly to you all, or there might be some that are just open to whoever might want to answer. I think this is a really important part of this webinar and presentation to kind of give anyone who's watching this, either live or recorded, really the perspective of what it looks like from each voice here. So the first one I think I am going to throw at Russ. Russ, what do you think contributes to mediation being successful or unsuccessful? What are some factors from your experience?
I think the most important thing that that I see is to get both sides to where they're pulling from the same side of the rope. And what I mean by that is, instead of being, I do also a lot of things like divorce mediation, and this is a lot like that. And sometimes when the parents and the school, maybe the trust aspect has been damaged in some way based on their prior interactions with each other. And so they come with a lot of times with an adversarial mindset, and I'm trying to get them to be more collaborative. And so I think that is the first thing that I really want them to do. Now, that's obviously easier said than done. And our good example is, you and I were at one where there was no trust. The whole thing was broken down.
Mm-hmm.
And so that was a very, very difficult mediation to have to deal with. But that's one of the main things that I think really contributes toward the success of the mediation.
Just viewing each other in that, kind of like what Rob had mentioned earlier, in the ally way, and walking in, even though there's been broken trust, right? But walking in, having that, I mean, I hate to say it this way, but like almost like that Pollyanna attitude of like, we're going to come in, and just by the nature of agreeing to this mediation session, that means that both parties are willing to gratefully listen to one another. So keeping that in mind, is that kind of where you're going, Russ?
Right. And I think that when I contact both the school and the parents prior to the mediation, I like to try to emphasize that and to have them, and they might want to air grievances, but I'm not there to air grievances. I'm there to try to help them as a neutral third party to get to the place where they can reach agreement.
Okay. Perfect. Thank you, Russ. Jackie, from the school side of things, what is one thing that you think is really important, or a couple things, from school perspective, preparing? What can schools do to help get prepared and think through what that mediation is going to look like, or making sure it's as successful as it can be?
I think the first thing is just making sure that you have all of your ducks in a row. Make sure you have all of your information that from my perspective as the director. I wanted to make sure that I had talked with the school psychologists and looked at, do we have data to support what we've been doing? Look at the behavior plans, meet with the teachers, look and make sure because there probably are things that both sides could give a little bit on, and there are probably things that you think, oh, maybe we could try this instead, or we didn't try this, we could do this a little bit differently. And so I think really trying to be open and work collaboratively with your school team first to really make sure you understand what the issues are and what the parent is potentially struggling with, and what kind of things we could maybe do to do it better, because obviously something's not working and there's some breakdown in communication. And so really trying to make sure that you know what's going on and that everybody is doing the best quality work that they can. I know that was important for me to work closely with my team, but then also I think when you're preparing is just making sure that and I know this has been said several times, but that making sure when you are communicating that you aren't getting defensive, making sure that you are communicating and speaking in a way that hopefully you are all working together. And it's hard because this kind of a situation, at least in my perspective, it was very intimidating. It was scary. I had no idea what I was getting into. And so it was, you have some of that anxiety. So I think that making sure that you deal with that, but you don't let it come out as getting defensive about things. I think it's important to keep that open mind and realize that, you know, you're not being attacked, you're not attacking somebody. And I think that's one of the real benefits of having the mediator, is that it helps having that neutral party, having that person there that can just be neutral and help facilitate that communication and problem solving together. So really kind of just looking at it as, and again, it's hard because it was anxiety provoking, but trying to reframe it in that it's really just a way to problem solve together. It's a way to help have some facilitation with problem solving, and kind of reframing it like that for yourself and for your team of individuals.
Thank you. That was great. I have two things that you said that I want to kind of piggyback off of. The whole like looking at your data and looking at all the things you've been doing. That could go one of two ways, because here's what's interesting. You know, we have sometimes schools, when mediation is moving forward or it's going to occur potentially, they have this perception that it is this legal, almost like a due process hearing. And they're like, well, we've got the data to back up our decisions. It's like, well, you're not presenting your evidence in mediation. You want to, so I love your perspective. You do want to look at your data to determine, have we been doing the right thing? Where are some ways we could give? That's a great rationale and perspective of, yes, that's when you want to look through your stuff, not to back up and say, here's how we're doing right. Because if that's your only game, why are you going to mediation? Because it's a negotiation, right? It's where can we look at what we've been doing? Where are some things we haven't tried? Are there some areas where we've been doing quote unquote wrong? And where can we give? So I love that you mentioned that as to why it's important to look at the data and where it can push you in a mediation. So that's huge. Thank you. And then the whole not taking it personally, that's also big. I think it's really hard. You know, parents feel the same, but in terms of school personnel, they can sometimes take things personally. And sometimes I think parents don't quite get that, because they're like, well, you're this conglomerate business, you're this big thing. Well, it's full of human beings, right? And so it's full of human beings who, in their mind, most of the time, they feel like, well, we've been doing all of these things, we've been doing our best. So to hear that maybe you haven't been, some people can really take that personally, but it's really not about you. It's about the student, and reframing that and building that bridge. So I think that's so big for directors and school personnel to keep in mind, that it's not about you. This isn't a personal thing. It's really about the kid. And that neutral party also can redirect to that. This is about the student. The focus is on the student and how we're solving these issues, right? So thank you. That was a great perspective. Ellen and Sharon, same question to you guys. What do you think is important for parents? Because you guys have been in lots of facilitated IEPs and mediation. So for preparation for mediation, what do you think is really important for families to do to prepare and get in the right mindset, or whatever that looks like for a mediation session?
Well, I think you guys touched on it already, but we really reiterate to families to be prepared with that agenda and stay focused on those things that you brought to the mediation to begin with, because oftentimes they'll want to go back, you know, what about a year ago when you did blah, blah, blah. And so, sorry. And so we really try to keep them stay focused. And so helping them get that agenda together and be prepared, and also being open-minded, you know, that this is a negotiation process, going in there, being willing to say, okay, I really want 5 days of speech, but you know, I can negotiate down to 2, you know, that kind of thing. And so that's something we really work with them on, and communicating effectively, because they're angry too sometimes. And the focus is about that teacher that didn't do the right thing, that in their mind.
Right.
And so we really have to help them, you know.
Right. And not focusing, you know, the law wasn't written, and we explain this to parents, for educators, and it wasn't written for parents, it was written to protect the child.
Mhm.
And so if we stay focused on the child and don't write some big narrative, you know, prepare in an outline form of what you want to talk about, because that is really, really distracting. And then we also go over, which Rob did so eloquently, was what part of Part B did the district violate? It can't be because they're angry or they don't like the superintendent or somebody gave me a dirty look. And we go over all those things over and over again, how to effectively communicate.
Thank you guys. That's such a good perspective. Okay, so let me think through here. Russ, I'm coming back to you. Okay. Talk about whenever you have to potentially caucus, what Rob had mentioned earlier, when you have to break the parties up. What are some situations in which you find that to be necessary? Because explaining that to parents, there's a variety of reasons why that might happen. But what have you found when it's time to caucus? How do you determine that that might be an appropriate time if it's something you're deciding or bringing up, or the school or the parents requesting it?
I think the thing about mediation that really is attractive to me after having a career in litigation is to actually the study of people. And I think this goes directly into when I might call for a caucus, because there are times where I can detect by either body language or by the words they're using or the lack of words, that especially for a parent, they start shutting down. And then I'm going, now it's time to split you people up, because I have to get the parent re-engaged. And sometimes they just feel intimidated. And because maybe, for instance, the school is there and their attorney is there, and the parents are unrepresented, or hopefully they have an advocate with them. But even if they don't, then they're on an island.
Mhm.
And so I try to balance that. But being the neutral, I'm trying to just keep everybody on a level playing field the best I can. So that's one thing. And then sometimes if it just becomes too emotionally charged, let's say the parents, I'm just going to use, parents or school. The school says, well, we're being insulted. I take offense at that, whatever it is. Or the parents just don't feel heard, and I'm trying to get them to the point where they are trying to diffuse the emotion of the thing. So that's when I start really seriously considering a caucus. And then I want to spend time with the parents to try to get them to breathe again, and to get them to where that they are re-engaging. And I don't know. I mean, I've only been doing this for 2.5 years. Rob is, when he mediates, it's like an orchestra, and my mediations are like AC/DC.
No,
Come in there like a freaking blunt instrument. So, but one of the things that I really try to do is just to get everybody back engaged, and if they're shutting down, then I've lost,
right.
and I have to get them back engaged.
I think that's really good points, Russ. And every mediator has their own style. So AC/DC is great, as is a classical orchestra, as is, I don't know, country something or other. I don't know. It's all great. But I think what you mentioned in terms of like keeping that neutrality is really difficult. I mean, I've been able to observe a couple of sessions now. I run the program, but I don't provide the services. It would be really hard for me to not be like, what are y'all doing? Just come to an agreement here, So I envy your patience and ability to do what it is you do. And so when you notice that a parent is feeling outnumbered or shutting down, you go to them. When you're offering going back and forth in caucuses, I've seen this. You're kind of the mouthpiece for both parties back and forth. And it can be viewed as like, oh, well, now you're telling me what the school wants. Now you're telling me what the parent wants. But that's your job on both sides. And I think maintaining that neutral position while supporting both parties is really difficult. And so I appreciate your perspective. Rob?
Yeah, Russ said something that made me think about this, and I didn't mention it in this short presentation. When you are meeting, when the mediator does meet with the parties in caucus, there is that regular confidentiality that we talked about already, where the discussions, cannot go on into due process or anywhere else. But there's another aspect of confidentiality that I like to share with the parties just at the beginning of mediation, and it ties into what both of you were just saying. And that is, if I'm meeting with the parents, well, part of what we might be doing is maybe looking at some other alternatives or some other options, or really considering what they might be willing to do without actually putting that out as a proposal yet. I'm always going to say to them that at the end of my time with each party separately, I'm going to find out specifically what I have permission to share with the other party. So sometimes the parents, it could have been the school also, might be willing to say, this is what we might be willing to do. We don't know if we're there yet. These options are not completely off the table, but I'm not ready to necessarily say that yet and make that a proposal. So I just want to say that because it goes back to what you were talking about. And I say that to folks at the beginning when setting the whole thing up, to say this point. You need to feel like I want you to feel that you can trust me in our private conversations, because they are private unless you give me permission. And I don't know if that makes sense to everybody, but that's, I think, really, really important for keeping that neutrality that Russ and you, Allison, were both just talking about.
That's a really good point.
Allison, I do the same thing. Before I leave the room, and I tell them this when I'm first meet with them, is when I'm doing the basically the guidelines of the mediation, and I will say, if I'm meeting with you separately and you are considering an offer, before I go and give that offer to someone else, before I leave the room, I'm going to say, okay, here's what I have. Is that the offer that you want me to present to them?
Mm-hmm.
And so they know that I'm not going in the other room and go, you will not believe what those people are talking about.
Right. Exactly. That's a really good point. And it's a interesting, unique position you guys are in that role. And so and it's an important position. So I do appreciate it. I want to go back to Sharon and Ellen. And I think Robin mentioned this earlier. Mediations don't always result in an agreement. That's the intention, right? The positive aspect of it is they're willing to meet in that session knowing it's a negotiation, knowing it's creative thinking, being willing to listen. So like that's already a step forward, right? But what happens, or what could be an outcome, or what is it that you help parents understand if you've gone through a mediation and it didn't result in an agreement, and they weren't able to resolve their issues? What are some perspectives that you guys might have from the parent side of things?
Well, I mean, we encourage and foster that early dispute resolution as early as possible.
Mm-hmm.
Sometimes when it's not reached in that agreement, we oftentimes will say, well, let's go back and relook at what are we really asking for, that because the parents have to feel safe in those mediations, they have to feel heard. And
Mm-hmm.
so going back to the original and saying, where's the miscommunication happening at that we can potentially help you with, And if not, we go on with the additional, here's your other procedural safeguards that you can look at. So Sharon, do you have anything?
That's perfect. We train and inform. We don't tell parents what to do. So we give them choices, and of course, we always give them options.
Mm-hmm.
And I mean, an option could be a state complaint, well, all of the procedural safeguards, but we go over them with that. So we try to make it better for kids.
Yeah. Thank you for that. And that's perfectly right. Mediation is an earlier option. And like Rob had mentioned earlier, it keeps the decisions in the hands of the parties, right? And they could certainly have other non-voluntary options like a state complaint or like due process. But the decision remains in the hands of the state investigation or the hearing officer, depending upon what route they've gone. So it may not come out the way you like. In that either, because they have certain things they have to go by in making those decisions through the complaint or through a hearing. So Thank you. I think that's a really good point, and how advocates can be really helpful for parents during mediations of, okay, hang on, let's reframe, because that mediator can come in and help to do that too. But like you're there to help support them in particular and to support their effective advocacy to meet the needs of their child of like, let's reframe about what it is you're really wanting and where you can bend and give and what are your priorities. So I think that's really, really helpful in order to let the parents not feel so alone or isolated, particularly if the school does have sometimes they have big groups there, even though we do try to tell the school, be really careful about who you have at this session. These are the only people required. You want to make this parent feel comfortable as well because you're going into this negotiation session, right? So making sure that that stays as balanced as possible is important. Okay, so Jackie, what is one thing that you've seen the mediator do that you feel like was helpful to the parties? Is there a particular like tactic or thing that occurred that was helpful in a mediation session?
I think that, we've kind of touched on this before, but just being able to stay neutral, being able to really not kind of get riled up, not to rile anyone else up, but staying neutral. I really appreciated at the very beginning going through and laying out all of those, all of the rules, whatnot, the expectations. And it was helpful again for me since I had never been in one and didn't really know what to expect, knowing the things like it's okay to take a break, that we can take a break at any time, knowing that, we can all stay together and talk, or we can separate and caucus and go out. So having all of that laid out right up front was really helpful to me. Because it is, at least in my case, it was a long process. It was, many hours long. And so when you get started and you kind of go through each of your perceptions of why you're there, just that alone was enough that I felt like we needed a break after that, because it was just, that's a lot of emotion when people are kind of going through what their perception is and why they're there. And so that was helpful that after, I finished being able to kind of explain where we were coming from the school's perspective, it was really helpful to know that I could ask for a break and that had already been, laid out, that was an option. So that was helpful to me, having that break, and then also knowing when I felt like it would be better for us to speak separately. The mediator, I think, kind of read my mind, and I was about ready to say that. And then the mediator presented that option and I was like, oh, okay, that's perfect. Yes, that's exactly what I want. So that was helpful. I found just the whole, the whole process, the whole demeanor and all of that. It was a very pretty calming presence. And so I think that just helped it really be more effective. So.
Thank you. I think that's really important in terms of that setting the stage. And I think we had mentioned this earlier about, the timing of mediation. When they're explaining the confidentiality, those communication expectations, here's how this session's going to go, here are your options. And now let's just have an understanding of why we're here today. It's just sort of like the opening remarks, basically, if I want to make it formal. Even just which, the purpose of that is for both parties to really have an open and honest understanding of each other's perspective at that moment. But that whole beginning intro piece takes like an hour. And so for people to think mediation can be knocked out in an hour and a half, I'm like, you haven't even really gotten to negotiations in that first hour, because it's so important to do those things that you're talking about. And then the watching, like Russ had mentioned earlier, watching for signs, whether that's the school or the parent, they're having to step back a little bit, even though they're leading that session, but watching people and looking for signs of shutting down, getting overwhelmed, whatever the case may be for either or both parties. So thank you. Let's see. Okay, Russ, we've got a couple minutes, so we can at least do one or two more questions. What is your mindset? Like when you're getting ready to go into a mediation, what is it that you do and walk through to help prepare yourself for what could be really smooth, what could be contentious? For these sessions, what do you do to prepare yourself?
Well, the first thing, and I think both for the school and the parents, it's something that I like to tell them when I talk to them before the mediation, and that is, hey, I've talked to you or Rob to kind of get a better lay of the land of what's really going on with this case. I don't go into detail with them, and fortunately, we're able to go in a lot more detail privately to where I have a better understanding, because I want to know what the parents and what the school's mindset is before I show up. And then what I have to guard against, though, and be careful about is that I have this thing pictured in my mind of how this whole scenario may play out, and then I get there, and then what I'm actually seeing may be totally different. And so let me just give you an analogy. So I used to referee high school football, and let's say I'm on the sideline, and I have, obviously, every coach wants a call against the other team every play. And so I'm following the play down there, and the coach is screaming at me, "There's a hole, there's a hole." If I don't see it, then it doesn't happen. It didn't happen. It didn't exist. But if they turn in a certain way and I see that there's a mugging going on from one player to the other, then I'm going to throw the flag. So I want to make sure that I'm not coming into the mediation ready to throw a flag on one side or the other when I'm not seeing it. So I have to be careful with that. So that's part of my mindset.
That's a really good point. And I'm sure you have to do some self-talk with that quite a bit. I could understand that because you do have an understanding of what's going on. You've got the agreement forms, you've gotten some insight as to here's the crux of the issue. And no human truly has no bias, right? And so you have to do that talk of maintaining that neutrality in that session and not letting any inherent bias one way or another influence what it is you're doing. And so I appreciate that analogy of how you've done that and related it to another part of your life. So that was helpful. Okay, Ellen and Sharon, what if you could, sorry, I'm gonna ask kind of a random one, but if you could give like one piece of advice to parents, if they're considering mediation or about to go into it, if you were only able to tell them one thing, or is it possible that you might narrow that down and share that piece of advice if you've got something that you would want them to know?
Focus on the issue at hand, and communicate that effectively. And that's really what we try to help them with.
You're angry and try not to bring it to the meeting. I mean, we're there to help the student, the child.
And the process.
And to stay focused on the child.
Okay.
It's real hard which we always say this, it could be a hostile learning environment, which is not an IDA issue. It's more of an Office of Civil Rights issue. But, I know that there are times when it becomes hostile on both sides. And it's really, really important that they write down things before they go to the meeting, but not some long narrative that they get all confused. And it's just keep it simple.
Yes.
Okay. So focus on the issue for the child.
Yes.
That's good advice. Jackie, how about you? Same for schools. If you had a director call and was like, "Oh my gosh, I'm about to go into mediation," or "I've got a mediation scheduled next week." If you had like 1 minute or one piece of advice to give them, what would that be?
I mean, similar along the same lines is just to remember that we're all in this because we want what's best for the student. Nobody is in this for any other reasons. We're all in education because we care about students and we want them to be successful. And so even, on the tough days and even when we have, tough families or students, ultimately that's what we all want, hopefully, at least if we're in this field, is that we want students to succeed. And so, I try to do that a lot when I'm thinking through it. If I'm getting frustrated by family, they're wanting what's best for their kid, and I also want what's best for the students. And so just really making sure we're all ultimately on the same team. We just have to find a way to get where we're communicating and working together instead of against each other. So like Russ said, you gotta be on the same side of the rope. One of my favorite sayings that I say a lot is "don't pick up the rope." And so, you can't have a tug of war if you only have one person. If you have two, both tugging from different sides, that's where you have some conflict. And so I loved it. He brought up a tug of war analogy too, because that's my saying all the time is don't pick up the rope. So just keep working together as best you can.
I love it. Thank you so much. So I know Rob's going to pull up the QR code for feedback eval survey. But I want to thank you guys, Russ Cochran, mediator for CERC, Sharon Long, executive director at Oklahoma Parent Center, Ellen Kimbrell, associate director of Oklahoma Parent Center, and Jackie Johns, director of special services at Collinsville. Thank you guys so much for being here and for serving on our panel. I think this is huge and hopefully very helpful for anyone who's considering or preparing to go into mediation. So I really appreciate y'all's time. Rob, did I miss anything else?
No, thank you everyone on the panel for participating. Really appreciate this discussion. I think it was very helpful. And thank you to those who've attended today. You could use this QR code to do a little participate in a brief survey. And also those that are watching this will be able to do that as well later on. But thank you, everyone. Hope you have a great rest of the day. And I guess our next webinar, Allison, I don't have it in front of me right now, but we don't meet, I believe, next month. Our next one is in January. And that webinar is on alternate diploma and transition curriculum. And so I'm going to invite everyone to participate in that, sign up for that. Thank you and have a great day.
Thanks.
Bye-bye.
Bye.